Welcome to the MTC Report, the news behind the news with journalist Mark Taylor-Canfield.
This is an apple. Some people might try to tell you that it's a banana. They might scream banana, banana, banana over and over and over again. They might put banana in all caps. You might even start to believe that this is a banana. But it's not.
No collusion, no obstruction. He's a leaker. He's a leaker. He's a leaker. He's a leaker.
It's Lordy, I hope there are tapes. It's Lordy, I hope there are tapes. It's Lordy, I hope there are tapes.
Nothing. Nothing.
I did not have any private meetings, nor do I recall any conversations with any Russian officials at the Mayflower Hotel.
Nothing.
Let me say it again.
Hi, this is Mark Taylor-Canfield, and this is the MTC Report. I've written at the Huffington Post. I have a blog at Daily Kos. I'm a regular on the Jeff Santos Show, broadcasting from Boston on the Revolution Radio Network. And I also have a column at the Capitol Hill Times. I'm also Vice President of Democracy Watch News and contributing editor. So today I wanted to talk about the possibility of the President of the United States being indicted or charged with crimes. Now, this is a big issue only because Donald Trump's administration is turning out to be so corrupt, and there are already 4 members of his staff who are facing felony convictions because of different investigations that are going on. Well, I wanted to start this idea by letting you know this is very controversial, and there are differing opinions amongst law professors on whether a standing United States president can be indicted. Now, some will tell you straight up, and some people on my Daily Kos blog have commented on my latest article, will Trump be impeached or resign? People have said, no, you cannot indict a standing president. First, you have to impeach that person. Well, let's start at the beginning, okay? In 1807, this is where this whole controversy started. In 1807, Thomas Jefferson was subpoenaed in Aaron Burr's treason trial. President Thomas Jefferson received a subpoena to testify at the treason trial of his former vice president, Aaron Burr. In the subpoena, Burr asked Jefferson to produce documents that might exonerate him. Burr had already been politically and socially disgraced by killing former Treasury Secretary and Revolutionary War hero Alexander Hamilton in a duel in 1804. And then after killing Hamilton, Burr, still Jefferson's vice president, went into hiding to avoid prosecution for murder. By the way, the charges were later dropped. But Burr then concocted this seditious plan to enlist the help of Britain and Spain to create a separate nation in the southwestern reaches of the American continent, including parts of Mexico, which Burr would then presumably rule. Now, this outrageous plan failed miserably, and one of Burr's co-conspirators, General James Wilkinson, betrayed Burr, and he alerted Thomas Jefferson to the plot. Burr was subsequently hunted down and arrested in 1806 and indicted for treason. Well, Jefferson expressed in his personal papers that he felt no love or loyalty for Burr despite their former political relationship. Burr had run a close and very contentious election against the Republican Jefferson in the 1800 campaign. Only after Alexander Hamilton reluctantly lobbied for Jefferson did the House select Jefferson for the presidency. This was only one of many grievances that Burr held against Hamilton, and that led to that fatal duel, by the way. Well, Jefferson refused to appear in Burr's defense and released only a few of the documents Burr had requested, invoking his presidential right to protect the public interest. Now, if Jefferson's intent was to help get Burr convicted, then his refusal to supply documentation totally backfired. In the end, Supreme Court Justice John Marshall found Burr not guilty by lack of evidence. Well, the reason that Jefferson did this is because he felt that the president needed to be protected from indictment and subpoenas while conducting business as the head of the United States. He felt that if he had set a precedent by showing up in court and responding to the subpoena, that from then on every president would be brought before the courts and sued and indicted by the opposing party. At the beginning of this country, there were opposing parties. Eventually, there were opposing parties. The Federalists against the Democrats. The Democrats actually called themselves the Republican Party, though. It's very confusing, I know, especially for folks who have just moved to this country. But that is the truth of the matter. And we can get into that at another. The point was that Jefferson started this whole controversy. He just refused to acknowledge that the president was subject to subpoenas, which has led to the sense of immunity, okay? And from some points of view, possibly a false sense of immunity, because Georgetown University's Law Center put together a paper called "Can We Indict a Sitting President?" That was written by Susan Lowell Block, who's Georgetown University Law Center. And you can download this document free of charge. It's at scholarship.lawgeorgetown.edu/FACPUB/1560. So in this paper, Susan Lowell Block brought up this idea, is the president immune from indictment while he's in office? And although there are differing opinions, Professor Scott Howe, in his opinion, the Constitution cannot be read to provide a sitting president any temporary immunity from prosecution. And now this issue came up because of the Clinton versus Jones case. So this was an issue during the presidency of Bill Clinton. And that's where some of these law professors got their theories, is by studying that particular case. And that's what a lot of this paper actually also studies. But Professor Scott Howe says that there's no temporary immunity from prosecution. However, he believes, according to Susan Lowell Block's paper, he believes that policy arguments favor such an immunity as a matter of federal common law, if you understand what I mean. So while Professor Howe's analysis is similar to that of other professors like Professor Amar and Brian Kalt, his conclusion that the immunity is not constitutionally required can have very important implications. If immunity is only a matter of federal common law, then, as Professor Howe suggests, Congress can change it at any time. That's right, Congress can restrict its scope, it can eliminate the immunity entirely, or it can expand its usage. If, on the other hand, the Constitution provides the immunity, as some law professors believe, then Congress cannot eliminate it. So this isn't a very important issue. And according to Susan Lowell Block, Professor Howe goes on to examine how far immunity extends. He concludes that it should apply as well to the vice president. This is just common federal law. This is just a common law. This is not a statute. This is not a federal law. It's a common law. Okay, it's precedent. And by the way, I want to thank History.com for the information on Thomas Jefferson and the subpoena during the Veuer trial. But the New York Times also has a very interesting article written by Charlie Savage, and it's entitled, "Can the President Be Indicted?" Can the President be indicted? A long-hidden legal memo says yes. And this is what Charlie wrote. A newfound memo from Kenneth W. Starr's independent counsel investigation into President Bill Clinton sheds fresh light on a constitutional puzzle that's taking on mounting significance amid the Trump-Russia inquiry. Can a sitting president be indicted? This 56-page memo, locked in the National Archives for nearly 2 decades, was obtained by the New York Times under the Freedom of Information Act, and it amounts to the most thorough government-commissioned analysis rejecting a generally held view that presidents are immune from prosecution while in office. Quote, "It is proper, constitutional, and legal for a federal grand jury to indict a sitting president for serious criminal acts that are not part of and are contrary to the president's official duties. The Star Office memo concludes. Quote, in this country, no one, even President Clinton, is above the law, unquote. And that's the whole point. The president is not above the law. Richard Nixon tried to claim that if the president does it, then it's not illegal. Well, Trump is kind of trying the same tack, then. It's not going to work. And this idea that the president is immune from prosecution or indictment while in office is based on, as the previous professor pointed out, is based upon what Professor Scott Howe says is federal common law. It's not written anywhere. It's certainly not directly quoted in the U.S. Constitution that the president is immune while in office. By the way, Ken the Star assigned Ronald Rotunda, a prominent conservative professor of constitutional law and ethics, who Mr. Starr hired as a consultant on his legal team to write the memo in the spring of 1998, after deputies advised him that they'd gathered enough evidence to ask a grand jury to indict Mr. Clinton. Other prosecutors working for Mr. Starr developed a draft indictment for Mr. Clinton, which the Times also requested be made public. The National Archives has not processed this file to determine whether it is exempt from disclosure under grand jury secrecy rules. And this is as of July 22nd, 2017, that this article was published. In 1974, the Watergate Special Counsel, Leon Jaworski, had also received a memo from his staff saying that he could indict the president. In that instance, Richard M. Nixon, while he was in office, and later made that case in court. Those documents, however, explore the topic significantly less extensively than the Starr memo. In the end, both Mr. Jaworski and Mr. Starr let congressional impeachment proceedings play out and did not try to indict the presidents while they remained in office. Mr. Starr, who had decided that he could indict Mr. Clinton, said in a recent interview that he'd concluded the more prudent and appropriate course was simply referring the matter to Congress for impeachment, which is as per federal common law. As Robert Mueller, the special counsel in this latest inquiry, investigates the Trump campaign's dealings with Russia and whether President Trump obstructed justice, the newly unearthed Starr Office memo raises the possibility that Mr. Mueller may have more options than most commentators have assumed. Here is an explanation of the debate and what the Starr Office memo has to say. So why do some argue that presidents are immune? Well, nothing in the Constitution or federal statutes says that sitting presidents are immune from prosecution, and no court has ruled that they have any such shield. But proponents of the theory that Mr. Trump is nevertheless immune for now from indictment cited the Constitution's, quote, structural principles, unquote, in the words of a memo written in September 1973 by Robert G. Dixon, Jr., then head of the Justice Department's Office of Legal Counsel. The argument boils down to practicalities of governance. The stigma of being indicted and the burden of a trial would unduly interfere with the president's ability to carry out his duties, preventing the executive branch, quote, from accomplishing its constitutional functions, unquote, in a way that cannot, quote, be justified by an overriding need, unquote. That's what Mr. Dixon wrote. Well, in 1973, Mr. Nixon's Solicitor General, Robert H. Bork, submitted a court brief that similarly argued for an inference that the Constitution makes sitting presidents immune from indictment and trial. And in 2000, Rudolph D. Moss, the head of the Office of Legal Counsel under Mr. Clinton, reviewed the Justice Department's 1973 opinions and reaffirmed their conclusion. So what was Starr's office's stance on this? Well, in laying out his case, Mr. Rotunda played down arguments that permitting a president to be indicted would cripple the executive branch. Instead, he placed greater emphasis on immunity issues that the Nixon and later Clinton teams dismissed. Among them, he noted that the Constitution's speech or debate clause explicitly grants limited immunity to lawmakers for certain actions. Quote, if the framers of our Constitution wanted to create a special immunity for the president, unquote, he argues, quote, they could have written the relevant clause, unquote. So he also wrote that the 25th Amendment, which allows for temporary replacement of a president who has become unable to carry out the duties of the office, created a mechanism that would keep the executive branch from becoming incapacitated if the president went to trial. And he noted that if indictments had to wait until the president's term was up, then some crimes would become untriable, such as those where the statute of limitations had run out. Now, that could happen for crimes that do not rise to an impeachable offense, he wrote, citing the example of a president who punches an irritating heckler. Well, quote, no one would suggest that the president should be removed from office simply because of that assault, unquote, he wrote. Quote, yet the president has no right to assault hecklers. Or here's my aside, reporters under the Trump administration, unquote. Quote, if there is no recourse against the president, if he cannot be prosecuted for violating criminal laws, he'll be above the law, unquote. So what was it that the Supreme Court said? The Supreme Court in the United States has never addressed the question of whether a sitting president can be indicted and tried. But in a landmark 1997 ruling, Clinton versus Jones, it permitted a lawsuit against Mr. Clinton for unofficial accusations of misconduct before he became president, to proceed while he was in office. And in his 2000 memo, Mr. Moss dismissed this ruling, emphasizing that the burdens of being a criminal defendant were greater than the burdens of being sued by a private litigant. But in the Star Office memo, Mr. Rotunda actually deemed the ruling far more significant for the criminal question. Quote, if public policy and the Constitution allow a private litigant to sue a sitting president for acts that are not a part of the president's official duties and are outside the outer perimeter of those duties, and that is what Clinton versus Jones squarely held, then one would think that an indictment is constitutional because the public interest in criminal cases is greater. So, bottom line, could Mueller go where no prosecutor has gone before? Even if Mr. Mueller were to uncover sufficient evidence to indict Mr. Trump, decide that the legal arguments in the Star Office memo were correct, and conclude that he wanted to ask a grand jury for an indictment while Trump was president, all big ifs, yet another uncertainty would loom: whether he must accept the Office of Legal Counsel's analysis, even if he disagreed with it. The United States Justice Department's regulations give Mr. Mueller, as a special counsel, greater autonomy than an ordinary prosecutor, but still he must follow its, quote, rules, regulations, procedures, practices, and policies, unquote. They also permit Deputy Attorney General Rod J. Rosenstein to overrule Mr. Mueller if he tries to take a step that Mr. Rosenstein deems as contrary to such practices. So, there is no guiding precedent about whether the Office of Legal Counsel memos would fall into that category, or if a special counsel is free to reach his own legal judgments. But as Mr. Mueller's office investigates, the ambiguity about the rules could influence calculations in the Trump camp about how much to cooperate and how much to fight. And that was said by Renato Mariotti, a former federal prosecutor who turned defense lawyer. Quote, I'd be surprised if Mueller indicted the president for the same prudential reasons that swayed Starr, Mr. Mariotti said. But the specter that he might do that could have an impact on things. If I were on the president's team, I would say, I don't think it's likely that he would, but it's possible, depending on what the facts are. So I want to thank, Charlie Savage, who did a great job on that article in the New York Times. Yes, there is some real journalism in the United States, despite the fact that freedom of the press is under duress, and that we're ranked 43rd in the world in terms of press freedom by Reporters Without Borders. But there are folks like Charlie Savage who write like that. There's folks like Danny Westneat at the Seattle Times who are very outspoken and not afraid to speak the truth passionately in their articles. And to also uncover the real information that people need to know instead of going along with the crowd and kind of the swarm phenomenon where all the reporters ask the same questions. There are some underlying questions that we really need to ask about our own democracy, about our society, about the nature of the presidency, and about democracy in general and freedom of the press. These are all issues that we need to address, and I will continue to address here at the MTC report. And another issue that's come up that I should address is, can Trump pardon himself? And this is about presidential clemency powers. The president, President Trump has consulted his legal advisors about the possibility of preemptively pardoning. President Trump has consulted his legal advisors about the possibility of preemptively pardoning his associates and possibly even himself to undermine the Justice Department's Russia investigation. And that was reported by the Washington Post. But John Dowd, Mr. Trump's new personal lawyer, denied to BuzzFeed that any such discussions had taken place. So who knows? There's always a they said, we said issue going on in Washington, D.C. these days where somebody is obviously not telling the truth, or somebody doesn't have their facts straight, but both sides claim they do. Either way, it's heightened interest in several key legal issues about the scope and limits of Mr. Trump's clemency powers. And this is also an article that you can find in the New York Times written by Charlie Savage, another excellent article. So can a president issue prospective pardons? Yes. Because in Ex parte Garland, a 1966 case involving a former Confederate senator who had been pardoned by President Andrew Johnson, the Supreme Court made clear that the pardon power extends to every offense known to the law and may be exercised at any time after its commission, either before legal proceedings are taken or during their pendency, or after conviction and judgment. So it's unusual for a president to issue a prospective pardon before charges are filed, let alone a conviction proving that someone committed a crime, but there are some examples. In 1974, after President Richard Nixon resigned to avoid being impeached in the Watergate scandal, President Gerald R. Ford shut down the possibility that his predecessor might be indicted by issuing a, quote, full, free, and absolute pardon, unquote, to Mr. Nixon for all the federal crimes that he, quote, committed or may have committed, unquote, during his presidency. Also in 1992, shortly before leaving office, President George Bush pardoned 6 Reagan administration officials over their, quote, conduct related to the Iran-Contra affair, including the former Defense Secretary Caspar W. Weinberger, who was about to go to trial on charges that he'd lied to Congress, and the independent prosecutor Lawrence E. Walsh, who'd been planning to use that trial in part to explore if Mr. Bush had any role in the scandal when he was vice president, accused Mr. Bush of a, quote, cover-up. So there you go. That is the past precedent. And could Trump pardon himself? Well, that's not clear, because the only limitation explicitly stated in the Constitution is a ban on using a pardon to stop an impeachment proceeding in Congress. And the only obvious implicit limitation is that he cannot pardon offenses under state law. But some legal scholars think a president cannot pardon himself either because it would be a conflict of interest. Well, obviously it is. In August 1974, 4 days before Richard Nixon resigned, Mary C. Lawton, then the acting head of the Justice Department's Office of Legal Counsel, issued a terse legal opinion stating that it would seem that Mr. Nixon could not pardon himself, quote, under the fundamental rule that no one may be a judge in his own case. Makes sense. That's sound legal judgment there. But she didn't explain what transformed that principle into an unwritten legal limit on the power the Constitution bestows on presidents. Other legal specialists have come out the other way. In 1998, the House Judiciary Committee hearing about the proposed impeachment of Mr. Clinton, for example, Representative Bob Good, a Virginia Republican, who's now the chairman of that panel, stated that, quote, the prevailing opinion is that the president can pardon himself, unquote. That's Bob Goodlatte. So there's no definitive answer because no president's ever tried to pardon himself and then been prosecuted, which would give the courts a chance to weigh in, I guess. But if Mr. Trump did purport to pardon himself and was later indicted anyway, it could create an opportunity for the Supreme Court to resolve this question. And then there's the 25th Amendment, which I also get questions about sometimes. This part of the Constitution provides a mechanism for temporarily making the vice president the acting president when the president is disabled from carrying out his duties. Well, in her 1974 memo, Ms. Lawton argued that it would be lawful for a president to declare himself temporarily disabled, receive a pardon from the vice president, and then resume his role as president. And under such a scenario, Mr. Trump could put his pardon on firmer legal footing by getting Vice President Mike Pence to do it for him. So these are things to watch out for. And once again, I want to thank Charlie Savage at the New York Times, doing great work on this. There are other articles about Trump's and Comey and an obstruction of justice, which is a whole other issue. The testimony by the former FBI Director James Comey that President Trump, before firing him last month, demanded loyalty, urged him to drop the investigation into his former national security advisor, and pressed him to, quote, lift the cloud, unquote, of the Russia inquiry, fueled accusations that the president obstructed justice, which was also something that President Nixon was accused of. So what is obstruction of justice? Well, several federal statutes criminalize actions that impede official investigations. And while some examples of illegal ways to thwart the justice system are specific, like killing a witness or destroying evidence, the law also includes broad catch-all prohibitions. For example, Section 1503, 1505, and 1512 of Title 18 have variants of language making it a crime if someone corruptly, quote, obstructs, influences, or impedes any official proceeding, unquote. Well, that could cover the FBI director to drop part of the investigation. And, well, could that cover asking the FBI director to drop part of the investigation and then later firing him? Well, in theory, yes. Such statutes were broadly drafted. Julie O'Sullivan, former federal prosecutor who now teaches white-collar criminal law at Georgetown University, says that the power relationship between a president and the FBI director could elevate a request to shut down a case into an act that amounts to impeding an official investigation. So, Trump did have legal authority to fire Comey, but the courts have ruled that otherwise lawful acts can constitute obstruction of justice if done with corrupt intentions. So these are a lot of the issues that we need to deal with. People in the United States should be asking themselves, what's the possibility of impeachment? What is the possibility of indictment? What are the possibilities of conviction during this presidential administration? Because asking the FBI to drop an investigation is an obstruction of justice, according to Representative Ted Deutsch, Democrat of Florida, after the initial report of the Oval Office conversation with Mr. Flynn, quote, obstruction of justice is an impeachable offense, unquote. So, there you go, folks. The Constitutional standards for impeachment and removal of a president if he's committed, quote, treason, bribery, or other high crimes and misdemeanors, unquote, are met by anything that a majority of the House and 2/3 of the Senate are willing to vote for. So that makes any predictions exercise in vote counting at this point, not legal analysis. And that, once again, comes from our sterling colleague, Charlie Savage, over there at the New York Times. This is Mark Taylor-Canfield for the MTC Report, reporting from Seattle on what's happening in Washington, D.C. It may be a long ways away, but it affects all of us. And, of course, there is a lot of conversation going on in Seattle about what's happening with the investigations into the Trump administration's dealings not only with Russia but selling off public land, the FCC voting down net neutrality, and a lot of the other issues that, if you really look into it and you really go to brass tacks, are not just political policies or political philosophy or strategy, they are corruption. There's a revolving door between corporations and the government. And so the foxes are in charge of watching the hen house at this point, folks. So watch out. And in the meantime, there's a whole population and generation of people who are resisting it as much as they can, which is not easy in a broken system, in a broken electoral system, and in a really weakened democracy at this point. But we should all stand for democracy and freedom of speech and freedom of the press and hold people accountable. I mean, it's It's our obligation as citizens. It's the obligation of our government oversight agencies. We've got to do it. It's the responsibility of the courts and law enforcement agencies. We've got to hold these people accountable. So if the president needs to be impeached, if the president needs to be indicted because of crimes and corruption, then should that person really be immune from the law? That is an exceptional president at that point. That is an untouchable, immune president. And I'm not sure that's a good idea when you're dealing with a democracy. This is Mark Taylor-Canfield reporting for the MTC report. As I said before, I've written at Huffington Post. I have a blog at Daily Kos. I'm on the Jeff Santos Show regularly as a guest journalist at revolutionradionetwork.com. And you can check out my YouTube channel where I have over 350 original uploaded videos. So I'm a busy guy out there on YouTube. And you can check out a lot of also some other things, some private detective radio plays that I do, where I play a private detective and write and act the parts and direct those plays. And some of my music, I'm also a musician. I'm DJ MTC. I do some political satire, animation, all sorts of stuff you can check out. And a lot of free movies. So, and please like this video and subscribe to my channel. This is Mark Taylor-Canfield for the MTC report. Until next time, thanks.
No collusion, no obstruction. He's a leaker. He's a leaker. He's a leaker. He's a leaker.
Tapes, Lordy, I hope there are tapes. Tapes, Lordy, I hope there are tapes. Tapes, Lordy, I hope there are tapes.
Nothing. Nothing.
I did not have any private meetings, nor do I recall any conversations with any Russian officials at the Mayflower Hotel.
Nothing.
Let me say it again. I believe health care is a right of all people. I will fight for a Medicare for all single-payer system. Second of all, right? You want to talk about rationing? You got 29 million people in this country who have no health insurance. How's that for rationing?
MTC Report, the news behind the news with journalist Mark Taylor-Canfield. We offer you independent voices and underreported stories about topics you won't hear anywhere else. Join us as we delve into the deeper issues behind the news stories of the day on the MTC Report.
Well, I feel badly for General Flynn. I feel very badly. He's led a very strong life, and I feel very badly, John. I will say this. Hillary Clinton lied many times to the FBI. Nothing happened to her. Flynn lied, and they destroyed his life. I think it's a shame. Hillary Clinton, on the 4th of July weekend, went to the FBI, not under oath. It was the most incredible thing anyone's ever seen. She lied many times. Nothing happened to her. Flynn lied, and it's like they ruined his life. It's very unfair. Thank you very much.
Democrat in the Senate who's looking into Russian election interference is going after Facebook, specifically fake accounts tied to Russia that bought $100,000 worth of Facebook ads during the 2016 election. Senator Mark Warner spoke at a panel event Thursday and called the purchase, quote, the tip of the iceberg. He's now calling on Congress to pass legislation aimed at social media companies and the sources of campaign-related ads. Now, looking back to the week after the election, Facebook CEO Mark Zuckerberg said the idea that his platform was used to manipulate voters was pretty crazy. The social media giant did a months-long review from June of 2015 to May of 2017. They found roughly 3,000 ads were connected to around 470 inauthentic accounts and pages. Going a bit deeper, they found the pages and accounts were connected together and operated out of Russia. According to the Washington Post, the ad sales were traced to a notorious Russian troll factory.
Recently publicly emerged on Twitter. He'd been using a sort of a ghost account earlier. Now he is tweeting a Bible verse this morning, just about 11 minutes ago. He says, "But justice rolled down like waters and righteousness like an ever-flowing stream," citing the Bible verse Amos 5:24 there. So the former FBI director, who was fired by Donald Trump, has been somewhat inscrutable on Twitter, but it seems to be sending messages from time to time. Not clear what he's trying to accomplish here, but tweeting out, "But justice roll down like waters and righteousness like an ever-flowing stream." Also, Scott, want to update you here with the developments at the White House. We were expecting to see a pool spray, that is, reporters brought in to see the president meeting with the Libyan prime minister. Reporters were brought out to the colonnade area to go in to get those pictures just a few moments ago, and then according to the pool, we were told that White House officials told them that the pool spray has been canceled. We will not be seeing the president on camera, and they're told to go back to the White House briefing room area. White House officials insisting that despite this being on the official schedule and wranglers bringing them into the area to hold, that this was never on the schedule at all and was never officially expected to be a pool spray. So some real confusion here about what was or was not on the schedule, but the bottom line being ultimately we are not going to see the president on camera. Reporters will not have an opportunity to shout questions at him about all this, and he will not have the opportunity to give his take on this before the cameras and before the world.